Good morning, viewers. It's the 2-1 class back again with the contracts presentation, supervised by Nkosana Maposa. This time we'll be presenting on contents of a contract. The group is as follows. Panache will be presenting on implied terms and warranties. Melody will be presenting on conditions. Celine will be presenting on special terms or exemption clauses, and I, as the group leader, will be giving you a brief summary about incidentalia, essentialia, and naturalia. Stay tuned.
Carrying on, I'll be presenting all the conditions of a contract. So, a condition in a contract is an event or act that obliges a party to perform an action or render a performance as specified in the contract. Basically, it's a certain qualification that's placed on a performance. There are five conditions of a contract. That is an offer, an acceptance, consideration, competence, and legal intent. And then the types of conditions in a contract. The first one that I'll start with is condition precedent. This one specifies an event that must happen before a person is obliged to perform duties specified in a contract. For example, an employer tells an employee that they will receive a bonus of 600 after they've completed an accounting course. The employer is liable to pay the employee. The employer is liable to pay the employee after the completion of the course. Some conditions. I'm also going to explain why it is necessary to add conditions to a contract. This is because they are a good way to both bind a party to a certain standard of performance, as well as render an agreement invalid if something happens. In particular, express conditions that avoid using specific language to define events can protect a party in the event of a lawsuit. Also, keeping in mind that some conditions can be implied and therefore are legally enforceable, even though they are not written. I'll leave more details to be explained by the next present.
Now, carrying on with the presentation, I'm going to talk about exemption clauses. Now, there are types of exemption clauses that include the exclusion clause, the indemnity clause, and the time limitation clause and the limitation clause. Now, for the purpose of understanding, I'm going to explain each clause by clause, starting with the exclusion clause. Now, these are terms which limit or exclude liability that a party would normally have in law, and then these parties could exclude or alter liability imposed by a term implied by law, what we usually call naturalia, or breach of contract, or misrepresentation made during any course of negotiations, or dialectual damages and losses. Now, an example of an exclusion clause is when the visitor parking permits at the university contain the following clause: the university accepts no liability whatsoever for damages to or loss from theft of vehicles and their attachments and contents, and from whatsoever cause arising. Now, vehicles are driven and parked into the university parking lot at owner's risk. Now, it is important to first determine if the exemption clause has been incorporated, and by determining incorporation, this is when we look at whether or not the exclusion clause had been incorporated, and the onus is on the person wishing to rely on it to prove, and whether or not the clause was signed with the covered subscriptor doctrine, and if the clause was printed on a ticket or sign, and the reasonable steps were taken to bring to the attention of the other party enshrined in the ticket case rules, and if the document containing the rules was referred to, as in like incorporation by reference. Now, in the case of Afro Health versus Stridom argued that he did not know there was an exclusion clause and that the administration clerk had the legal duty to point out to him. Now, the court found out that the hospital could rely on the exclusion clause and they were not liable. The court relied on the fact that the exclusion clause was expected and the administration did not have the legal duty to point out the exclusion clause. Now, exclusion clauses exist for the protection of one party. However, in some instances, they lead to exploitation, especially where there is little negotiation power. Now, I'm going to talk more on the limitation clause. Now, this does essentially the same thing as the exclusion clause, merely not the exact same. Now, a party is not totally excluded from liability in such an event, but their liability is limited, which cushions the blow in some small way. For an example, a liability clause might state that in the event of an injury, the company will pay up to $300 in damages. It will often be phrased in the negative. However, to state that the company will not be liable for more than $300 damages. Now, this effectively limits the amount of damage that the company can take while still granting some liability to its partners. And this is generally seen as more acceptable in the court. Now, I'm going to talk about the time limitation clause. Now, this is a standard clause that limits the period of time in which a party can file for contractual claims against the other party. Now, this type of clause was evident in the case of Napier versus Parkinson, and I'll not go much on that case. And I'll talk about the indemnity clause. Now, indemnity clause are the most complex of the three exemption clauses. Now, in an indemnity clause, one party agrees to indemnify or to absorb the losses caused by the other party, hold harmless, or to defend the other party. This means that rather than seeking to sue for damages, the other party agrees to protect the other party in case of a lawsuit. Suppose, for an example, that your company develops some technology and sells it with an indemnity clause. A client purchases your technology and is sued by the other company, claiming that the technology is a copy of theirs. You're then liable to cover for the cost of the lawsuit for your client, provided that an indemnity clause was included. Now, this is all that I have to say about the types of indemnity. The types of exemption clauses that include the indemnity clause, the exclusion clause, limitation clause, and the time limitation clause. Now I'll leave the floor to the other presenter to carry on with the presentation.
As my fellow colleague mentioned, I'm going to present about the implied and express terms in contract law. But before we go any further, it is quite important for one to know what we mean by terms or a term in contract law. And by a term, we mean the promises agreed upon by the parties in a contract. Statements which are made in order to induce someone to enter into a contract are not part of the terms, but they are just mere parts or accommodations within the contract. So I'm going to look into the express and implied terms. So firstly, we have to know about the express terms. And by express terms, we mean what was said orally or in writing when the contract was being made. And the judges tend to uphold the principle that contracts speak for themselves and contracts or agreements should be interpreted according to its four corners. So firstly, we have to look at the golden rule when it comes to contracts. By the golden rule, it simply means that the contract should be interpreted within its grammatic meaning. Secondly, when you talk about the parole evidence rule, we simply mean that the terms of a contract will be interpreted within the four corners of the agreement, and the court tends to believe that the contract speaks for itself, and when it is reduced to writing, it becomes the memorial exclusive of the contract, and the courts will not include external means or external evidence when they are trying to interpret the contract, but they'll just simply use the paro evidence rule. Going to go much into the paro evidence, but you have to know that the exception of the paro evidence and also the criticism of this paro evidence rule. So, thirdly, we are going to look at signed contracts. And when we're looking at signed contracts, we should look at the caveat subscriptum. And by the term caveat subscriptum, we simply mean that a person is bound by the signature which he signs on a contract, whether the person had read the terms or not. The signature binds him to the terms which comes along with the contract. And it is also quite crucial to note that if a person signs a contract with some blank spaces, then the person is ready to allow the contract to change because the person did not consider making the contract to be filled in the blank spaces. But however, our courts in Zimbabwe consider what was written below. And fourthly, we also have to look at the unsigned contracts. Signed contracts, we simply mean such things like notices, tickets, just to mention a few. For example, if a person enters into a bus, the terms that comes along with the tickets that he or she is given simply are the terms that the person will be complying to. And according to Christie, if the person reads the terms which will be written on the ticket and continues, it simply means that there is consensus and the person is agreeing to the terms. And by this, we mean that the terms that are written on the tickets or on the notices, although they are not signed, then they make the person bound to those terms.
Hello viewers, so I'll be talking on implied terms. So implied terms are not reduced into writing, but are read into the contract through the conduct of the parties. So we are saying, in other words, they are not explicitly mentioned or written in a contractual obligation between bilateral parties or many parties that might be involved into the contract. So in other words, normally these are terms that are so obviously that the parties do not think it's necessary to spell out at the time of contracting. And then so we have terms that are implied by the law. So these terms are read automatically into a contract, either by statutes or by common law, even if the parties do not reach on their inclusion. Let's say, for instance, Section 22 of the Hire Purchase Act provides that a buyer cannot waive his rights under the Act. So this provision is read into every Hire Purchase Act or hire purchase contract to prevent buyers from waiving their rights. So in other words, if this provision of the section is read literally, that's when the implied term come into form. So we have terms that are implied by trade usage. So these are universally and uniformly observed rules, practices, or customs adopted by a certain trade, business, or profession that can be read into the contract of the trade. So now, such terms are implied by the trade usage when a particular practice in a trade is so common that the people involved in that trade will assume that the practice is a term of their contract. So we are saying, there are certain trade customs. I like this part because it describes of customs, which means there are things that people believe in, which means that it should not explicitly be mentioned, but people just understand and they know that these are tacit terms. So I think I've done justice in terms of implied terms, as I synoptically give just a few points. Thank you. I would also like to talk on warranties. A warranty is a term whereby a party assumes contractual liability for the existence of a certain state of affairs. In other words, it is a contractual statement of fact made by the warrantor to the warrantee, which is usually contained in a share or asset purchase agreement. For example, the seller of a car gives a warranty that the car is a 1996 model That is to say, a legally binding commitment forming part of the sales contract, which assures the buyer that the product is free from defects. The effect of a warranty is that it imposes absolute liability on the person giving such a warranty. Failure to comply with the warranty amounts to breach of contract. The innocent party is entitled to remedies for breach of contract. Warranty must be distinguished from a condition since there is a different consequences, and the test is the intention of the parties. So with all this, I think you have a clear picture of the conditions and warranties in line with any contract or any type of a contract. Thank you.
Conclusively, I'm going to give you a very brief summary about the terms that I mentioned. So to start with, I'm going to talk about essential terms, and the Latin maxim for essential terms is essentialia. So these are terms that specify on what type of contract and what type of object is going to be bought, if there's any. So this term cannot be excluded from the terms because parties need to know what they're getting into. Then there are natural terms or naturalia terms. These terms directly from the operation of the law. Parties don't need to include the terms in the contract. The law operates the natural terms, and they just stem naturally from partaking a contract. Then the last thing that I'm going to talk about is about incidentalia terms or incident terms. These vary the defects of the object that is bought or that is going to be bought. So the parties can vary the objects by, for example, including the as is clause or the footstoods clause that states that the party has to take the object in question as it is to avoid disputes on contract. So this is all we had on contents of a contract. Let's hope you guys enjoyed and you guys benefited a lot from this discussion. Don't forget to like and subscribe.